Yes, Namaste, good morning and welcome. Today we'll start with one more commercial law, that is Sale of Goods Act 1930. Okay, so before 1930, this law was part of Indian Contract Act 1872 itself. In the year 1930, the provisions dealing with the contract of sale of goods were removed from the Indian Contract Act, and a separate law was made called as the Sale of Goods Act 1930. Okay, so let's start with the Sale of Goods Act 1930, that we will discuss later. Okay, so today we'll discuss the Sale of Goods Act 1930. So once it is done, we will discuss the Limited Liability Partnership Act. Done? Yes. So let's start. The Sale of Goods Act, the Sale of Goods Act 1930. The Sale of Goods Act, Goods Act 1930. 1930. So this act, again we know section number 1 provides how many provision? 3 provisions. What are the 3 provisions? Short title, extent, commencement. The short title of this act is the name of the act, the Sale of Goods Act 1930. To extent, this law is applicable to the extent of whole of India. Entire India, this law is applicable. Commencement, it came into force from the date 1st July 1930. So before 1930, these provisions were there in the Indian Contract Act 1872 itself. Okay, so section number 1 provides how many provisions? 3 provisions: short title, extent, commencement. The short title is the Sale of Goods Act 1930, extent the whole of India, commencement the 1st July 1930. Okay, so if you observe the name carefully, there are 2 important terms in the act name itself, that is, one is sale, another one is goods. So let us understand the meaning of both the terms. What is the first one? Sale. So sale is also called as contract of sale, a contract of sale. Section number 4 of the Sale of Goods Act defines what is a contract of sale. So obviously it is a what? Contract or an agreement. So what is contracts are? An agreement which is enforceable by law is called as a contract. So it is a contract in which the seller either he transfers, most important, transfers means he will transfer it immediately, or agrees to transfer, what? Property in the goods. Important, he agrees to transfer what? Property in the goods. To whom? To a buyer. To a buyer. At free of cost? No. For a price. For a money consideration called as price. That is called as what? Contract of sale. Definition of contract of sale. For example, in this case, what is contract of sale? It is a contract, means it must satisfy all essentials of valid contract, in which seller, who is seller? Who is a seller? The law provides seller means one who sells or agrees to sell. Either he sells it or agrees to sell what? Goods. He is called as a seller. Selling means what? Immediate transfer of ownership. Agreeing to sell means what? He will transfer it on a future date. Both the cases he is called as seller. If I sell the goods today and I give the goods to you today itself, that is, if I transfer ownership today itself, that is called as sale. When I enter into a contract today, but I will transfer ownership on a future date or after fulfilling condition, that is called as agreement to sell or agreement to transfer the ownership. So sale or contract of sale includes both the things, where ownership is transferred or agrees to transfer property in the goods. Now what is property? Nothing but the ownership. Ownership in the goods. To whom? To the buyer. For what? For a price. That is considered as a contract of sale. And again, who is buyer? Who is a buyer? Simple. One who buys or agrees to buy. One who buys or agrees to buy. He is called as what? Buyer. For what? Price. What is price here? Nothing but considerations. So what is contract of sale? It is a contract in which a seller transfers, means he transfers it immediately or agrees to transfer. You should take into consideration the date of contract or the time of contract. If the ownership is transferred on the date of contract itself, it is called as transfers, means sale. When the ownership is transferred after the contract is made, other than the date or the time on which the contract is made, it is called as agrees to transfer. For example, if I enter into a contract today to manufacture and sell 100 kg of goods, that is called as what? Agreement to transfer, or agreeing to transfer the property in the goods. So sale includes both sale as well as agreement to sell. And most important thing is there must be a transfer of property in the goods. Now what is property here means? The ownership. There should be a transfer of what? Ownership from one person to another person. Okay. So I repeat for the last time. What is contract of sale? It is a contract in which seller, who is seller? The one who sells or agrees to sell. What he does? It transfers, means there is an immediate transfer of ownership, or agrees to transfer what? Property in the goods. What is property? Ownership. In what? Goods. To whom? Buyer. For what? Price. That is considered as a contract of sale. The next question comes to our mind is, it's a contract, sale is a contract in which the ownership of the goods is transferred. So we must understand what is the definition of goods. Definition of what? Goods. Most important, because entire law deals with what? Sale of goods, and we must know what is a goods for the purpose of better understanding of this law called Sale of Goods Act 1930. Section number 2 clause 7 defines the word goods. Section number क्या है? Section number 2 subsection 7 defines the word goods. As per this section number, goods means all kinds of movable property. All kind of movable property. So all the kind of movable properties are considered as what? Considered as goods. Chairs, desk and dusters, all these are considered as what? Considered as the goods. So all kind of movable property, and it includes few things, excludes few things. The definition of goods includes few things, excludes few things. What are the things which are included in the goods definitions? The first one which is included in the definition of goods is standing timber. What timber? Standing timber, nothing but trees. Standing timber, growing crops, sugarcane, paddy, then jowar, all these are considered as what? Growing crops. Growing crops. And the third one is grass. Or what? Grass. So all three are considered as what? Considered as goods, and these can be purchased and it can be sold. But the only thing is they have agreed to be severed. They have agreed to be what? Severed. Severed means what? Cut. Before the transfer of ownership. Before transfer of what? Ownership. They are required, or they must be separated from the land before ownership is transferred. Then they are called as goods. But if you sell a standing timber, the trees along with the land, that is called as immovable property. If you sell growing crops along with the land, it is called as immovable property. But when you separate that standing timber or a growing crops or a grass from the land, then if you sell it, it is called as what? Goods. Okay, so the definition of goods includes all kinds of movable property, including standing timber, growing crops, grass, which are agreed to be severed, that is cut before the ownership is transferred. But it excludes, or it does not includes, definition of movable property, that is goods, does not includes what? Immovable property. Immovable property is not considered as what? Not considered as goods. Immovable properties are not considered as the goods. It also does not include current currency notes and coins. Current currency notes and coins. The currency notes and coins which are in circulations are also not considered as the goods. Current currency notes and coins are not considered as the goods. And the last one it does not include is actionable claim. Most important one. What claim? Actionable claim is also not considered as goods. I repeat, the definition of goods means all kinds of movable property including standing timber, growing crops, grass which are agreed to be severed, means cut before the ownership is transferred. It excludes, means the definition does not include immovable property, is not a goods. Current currency notes and coins, you cannot sell currency notes and coins, that is not considered as a goods. Actionable claim is not considered as a goods. Now what is actionable claim, sir? Most important. Actionable claim means it's a right to file a suit. Right to file a suit to recover unsecured debt. To recover what debt? An unsecured debt. Unsecured debt, we also call it as money recovery suit. If you have a right to file a suit to recover an unsecured debt, you can file a money recovery suit. In the law language we call it as what? Money recovery suit. So that right to file a suit for recovery of unsecured debt is called as an actionable claim. And if you want to transfer that right, that can be transferred only on a stamp paper. Why? Because this actionable claim is considered as what property? Immovable property, not a movable property. It is considered as what property? Immovable property. I repeat, actionable claim is considered as what property? Immovable properties. Now for example, let's say SBI Bank. SBI Bank has given a loan to whom? Loan to Mr. X. SBI Bank gives a loan to Mr. X. How much loan? Let's say 3 lakh rupees of loan. Now who is the creditor here? SBI is the creditor. Who is the debtor here? Mr. X is the debtor. And Mr. X promised to repay it within 3 months. Within how many months? 3 months. He has made a promise to repay within 3 months, but now X defaults. Who defaults? X defaults. Tell me, if X defaults, what bank can do? What is the remedy available to bank? Answers please. What SBI can do? Can it file a case against Mr. X? Yes, very good. It can sue. Who can sue? SBI can sue whom? Mr. X. Now, usually what happens, if you would have seen, when these vehicles loans are provided by the banks or any other loans are given by the banks, bank will not file a suit or take legal action for recovery of money, because banks are expertise in banking business, not in filing a suit or recovery of money. For that purpose, there are certain recovery agencies. There are certain companies called as recovery agencies who are expertised in loan recovery. Expertised in what? Loan recovery. And they also have a legal team which is expertised in these matters. So what they will do? They will assign whatever the right they have to the third party by a contract. That is called as assignment deed. Now, SBI has a right to file a suit against whom? Mr. X. This right to file a suit, is it secured debt or unsecured debt? Whatever the debt provided by SBI to Mr. X, is it secured or unsecured? The answer is unsecured. Why? Because there is no collateral security for repayment of loan. There is no security given by Mr. X. So it is unsecured debt. Now if SBI want to transfer this right to sue against X, can it be transferred, sir? Yes. Not as per Sale of Goods Act, as per Transfer of Property Act. Sir, why Transfer of Property Act, sir? Because it is considered as what property? Immovable property. What property? Immovable property. Now the SBI should make an assignment deed. What deed? Assignment deed. There should be an assignment deed, Assignment deed means what? Should be on a stamp paper. So why it is required to be on a stamp paper, sir? Because that right, whatever is assigned by the SBI is considered as what property? Immovable property. Okay. So now the definition of goods does not include actionable claim. What is actionable claim? Actionable claim. Claim means a right over somebody. Actionable claim means it's a right to file a suit to recover an unsecured debt. Is it transferable? Yes, that right can be transferred from one person to another person. How it can be transferred? By a contract. That contract should be on what paper? Stamp paper. Clear? This is the definition of what? Goods. And based on interpretations, various times the court have held that shares, debentures, bonds, then patent rights, copyrights, trademark, goodwill, and even electricity, gas, water, all these are considered as what? Goods. Okay, only this immovable property, currency notes and coins, actionable claim are not considered as goods and they are covered under the Transfer of Property Act 1881. This is the definition of what? Goods. Are we clear with the definition of goods, everybody? Okay, next. For the purpose of Sale of Goods Act, we can classify the goods into various types. So we can classify them into three types. For the purpose of what? Sale of Goods Act, we can classify the goods which we are gonna discuss into three types. What are the three types? First one is existing goods. Existing goods. Second one is what goods? Future goods. Existing goods and the future goods. The third one is contingent goods. Third one is what goods? Contingent goods. So first one is existing goods, second one is future goods, the third one is contingent goods. Okay, so now what are existing goods? The name itself indicates. You should take into consideration the point of entering into a contract or time of entering into a contract. Now if the goods are in existence, the goods are in existence when? At the time of entering into a contract. At the time of entering into a contract, or when the contract is made, they are called as what goods? Existing goods. If the goods are in existence, means they're already produced or already manufactured. That kind of goods, if you enter into a contract to sell, it is called as sale of existing goods. Okay, for example, if I enter into sell this pen, it is in existence, existing goods. If I enter into a contract to sell this mouse, it is considered as existing goods. Then comes the future goods. What are future goods, sir? The goods which are not in existence. When the contract is made, it is called as what? Future goods. Simple. The goods which are not in existence. Not in existence when the contract is made, it is called as what goods? Future goods. If they are in existence, existing goods. If they are not in existence, they are yet to be produced or manufactured. These goods are yet to be produced. Yet to be produced. The goods which are yet to be produced, future goods, means the goods which are not in existence, are called as future goods. They are yet to be produced, or manufactured. They are called as the future goods. Then comes contingent goods. What are contingent goods, sir? The receipt of goods. The receipt of goods by seller depends upon happening or non-happening of an uncertain event. Happening or non-happening. non-happening of uncertain future event. Uncertain future event. Then it is called as what goods? Called as the contingent goods. If they are in existence, existing goods. If they are not in existence, future goods. And if the receipt of the goods depends upon some event, collateral event, happening or non-happening of an collateral event, they are called as contingent goods. Okay, existing goods, let's say this pen, existing goods. Future goods, I enter into a contract with you to manufacture and sell it to you. When the contract is made, at that time goods are not in existence, that is called as future goods. Then comes contingent goods, the goods the receipt of which by the seller depends upon the happening or non-happening of an uncertain future event. For example, I enter into a contract with you to sell the goods to you, provided if somebody sells it to me. Let's say Mr. X sells it to me. If he sells it to me, then I will sell it to you. So here, I selling goods to you depends upon whom? X selling goods to me. If he sell it to me, if I receive goods from him, I will give it to you. I am bound to give it to you. If he doesn't give the goods to me, then I am not bound to give the goods to you. That is called as contingent goods. Okay. So if the goods are in existence when the contract is made, it's called as existing goods. If the goods are not in existence, they're yet to be manufactured or produced, future goods. The goods which selling of which depends upon happening or non-happening of an collateral event or uncertain future event, that is called as contingent goods. Okay. Now existing goods can again be classified into how many types? 3 types for the purpose of ownership. Listen carefully. How many types? 3 types. What are 3 types? The first one is specific goods. Specific goods. Second one is unascertained goods. Unascertained goods. Last one is ascertained goods. Ascertained goods. Now, what is the first one? Specific goods. Now, what are specific goods? Name itself indicates the goods which are identified. Simple. The goods which are identified plus agreed upon. Means you will agree what is the goods you want to purchase. If the goods are specifically identified plus it's also agreed by the parties with respect to what is that goods is, that is called as specific goods. When it is done at the time of entering into a contract itself. At the time of entering into a contract itself. Let's say in the go down there are 1000 mobile phones or there are 100 mobile phones. Out of 100 mobile phones you select 50 out of it. And then you enter into a contract to purchase it. Now you specifically identified 50 mobile phones out of the 100. So when you identify and agree to purchase 50 mobile phones, that is considered as what? Specific goods. Because you have clearly identified and agreed to purchase the specific quantity of the goods. Okay. Then comes unascertained goods. The name itself suggests, a name itself indicates these are the goods which are not identified. They are neither identified nor agreed upon by the parties. If the parties are not clearly identified or agreed upon with respect to the kind of goods they are willing to purchase, that is considered as unascertained goods. Let's say in the go down there are 100 bags of sugar. 100 bags. Now without identifying which 100 bags or what are those bags which they want to purchase, Mr. X made a contract with Y to purchase how many bags? 50 bags. Now are these goods identified? No, they are interchangeable, right? In go down there are how many goods? 100 bags of sugar. Out of 100 bags, X made a contract to buy 50 bags. That 50 bags can be anything. It is interchangeable. Because it is not separated yet, because it is not clearly identified, that is called as unascertained goods. Okay. Then comes ascertained goods. If there is a contract to purchase unascertained goods, after the contract is made, either the seller or the buyer with the consent of other party, that is, if it is by seller with the consent of buyer, or if it is by buyer with the consent of seller, other, appropriates the agreed quantity from the bulk, then it becomes what goods? Ascertained goods. Means in this case, X agreed to buy 50 bags of sugar. Now either X will go to the godown with the consent of Y, or Y will go to the godown with the consent of X, or both will go to the godown, and what they will do? They will take out 50 bags of sugar from the bulk. When they take out 50 bags, that bags which are separated now, that is called as what? Ascertained goods. Before it was unascertained, now it is called as ascertained. Sir, you can ask me a question. Sir, specific goods and ascertained goods both are similar, sir? No, because specific goods are the goods which you identify when the contract is made. At that time itself, or before entering into a contract, you identify the goods, then you enter into a contract to purchase. But in case of ascertained goods, there will be a contract to purchase unascertained goods. Then the parties goes to the godown, or then the parties identify and agree upon the particular kind of goods. That is called as ascertained goods. Okay. Appropriation means selection. Clear? For the purpose of transfer of ownership, we can classify the goods into how many types? 3 types. What are the 3 types? Existing goods, future goods, contingent goods. If the goods are in existence when the contract is made, are called as existing goods. If the goods are yet to be produced or manufactured, it is called as future goods. The selling of goods which depends upon happening or non-happening of a future event, it is called as contingent goods. Existing goods can be again classified into 3 types: specific goods, unascertained goods, ascertained goods. What is specific goods? If the goods are identified and agreed upon, you go to the mobile showroom, you select an iPhone, then you enter into a contract to purchase it. Specific goods. So if you identify and agree before or at the time of contract, it is called as specific goods. If you identify and agree after the contract is made, that is called as ascertained goods. When the contract is made, at that time if the goods are not identified nor agreed upon, that is called as unascertained goods. Okay, so these are the various types of goods. Now tell me, in what kind of goods there can be an immediate transfer of ownership? Immediate transfer means when the contract is made, at that time itself we can transfer ownership. In what kind of goods? Answers please. In what kind of goods there can be an immediate transfer of ownership? I can transfer it immediately. Very good. Existing goods. In existing goods, which one? Is the ownership is transferred immediately in case of unascertained goods? Very good. Only specific goods. Awesome. So in case of specific goods, there can be an immediate transfer of ownership, not in case of unascertained goods. Clear? Yes. So these are the various types of what? Various types of goods. I will give an example. You guys should tell me whether it is a sale of existing goods or a future goods or a contingent goods. Okay? Yes. Now let's say I made a contract with you to manufacture and sell 100 kg of 100 kg of iron, or let's say 100 chairs. This is sale of what goods? Existing. Very good. Future goods. Awesome. Now what if I enter into a contract with you where I agreed to grow paddy in my land and sell it to you? I agreed to grow paddy in my land, and whatever the cultivation comes or whatever the crops comes, that I will sell it to you. Is it a sale of what goods? Future goods. Okay, what goods? Future goods, because the goods is not in existence when the contract is made. For example, let's say the crops is still growing. I made a contract with you saying that sugarcane factory, I made a contract with you saying that whatever that crops comes, I will sell it to you only. I made a contract with you. That is called as what? Sale of future goods. Because the goods is not ready yet. That is called as future goods. Okay. So these are the various types of goods. And one more important definition, a term which is supposed to be known before we start topics, is delivery of goods. See, delivery is different, ownership is different. Correct, right? A delivery of goods is different, ownership is different. This concept of delivery I discussed in the Contract Act, bailment may. Correct, right? Yes. What is delivery? A voluntary transfer of possession of the goods. A voluntary transfer of what? Possession of the goods. Possession of the goods from one person to another person. It is called as what? Called as delivery of goods. And this delivery of goods can be of how many types? It can be of 3 types. Correct, right? What are 3 types? Remember, I discussed this in the Contract Act. Actual delivery, symbolic delivery, constructive delivery. Constructive delivery of goods. Actual delivery, symbolic delivery, and constructive delivery. What is actual delivery of goods? Where the physical possession of the goods is transferred. What is transferred? A physical possession of the goods is transferred from one person to another person. It is called as actual delivery of goods. Then comes symbolic delivery of goods, where the delivery of the goods happens throughout certain symbol or a token or by document of title. Document of title. That is considered as symbolic delivery of goods. Then what is constructive delivery of goods? Where the delivery of goods happens by acknowledgement. By acknowledgement of a third party. Acknowledgement of what? A third party. Acknowledgement of third party having the possession of the goods. Having the possession of the goods. Possession of goods. It is called as what? Constructive delivery or deemed delivery or implied delivery. If somebody is holding my goods, I sell it to Mr. X. Now he will acknowledge that he continues to hold the goods for Mr. X. By that, what is transferred here? Delivery of goods has been transferred. Okay. Keep this in mind. Delivery is different, ownership is different. Having possession of goods is different, having ownership is different. If you have the possession of the goods, it means you have the goods with you, not the ownership. For example, if you take goods on a bailment, in case of bailment, ownership is not transferred. Only what is transferred? Possession is transferred. Okay. And in case of sale, the most important thing is ownership, not the transfer of possession of the goods. Clear? So these are the basic terms to understand the Sale of Goods Act 1930. So we have discussed section number 1, short title, extent, commencement. Section number 4, definition of contract of sale. It's a contract in which who transfers? Seller transfers or agrees to transfer what? Property in the goods to whom? Buyer. That is for what? Price. That is consideration. That is called as contract of sale. And we discussed who is seller? The one who sells or agrees to sell. Who is buyer? Who is buyer? One who buys or agrees to buy. Then we discussed types of goods. What are types of goods? Then before that we discussed what is goods. All kind of movable property includes standing timber, growing crops, grass, but does not includes immovable property, currency notes and coins, and actionable claim. Correct, right? Types of goods: existing goods, future goods, contingent goods. Existing goods, again, how many types? 3 types. Specific goods, unascertained goods, ascertained goods. Delivery, a transfer of possession of the goods, a voluntary transfer of possession of the goods by one person to another person. It can be of how many types? 3 types. Actual delivery, symbolic delivery, constructive delivery. What is actual delivery? where the physical possession of the goods is transferred from one person to another person. What is symbolic delivery? Where the possession of the goods is transferred by certain symbols or document of title. It is called as symbolic delivery. What is constructive delivery? It is also called as implied delivery of goods. Okay, yes. So let us discuss these topics with the help of material. So module learning objective: after studying this module, the students will be able to learn about the various laws governing the essential features of contract for sale of goods, such as formation of contract of sale, subject matter of the contract of sale, price and conditions and warranties incidental to such contract. That is the object of this study. Okay, yes. The Sale of Goods Act 1930 provides a provision that regulates the contract entered into between the parties. Okay, yes. Essentials, conditions for sale and agreement to sale. Sale, a contract of sale includes what? Both sale as well as agreement to sell. Correct, right? And in case of sale, what is the thing? Ownership is transferred immediately. Agreement to sell, what is transferred? Ownership is transferred on a future date. Section number 4 of the Act contemplates the sale and agreement to sell. Section number 4 provides a definition of contract of sale. Contract of sale of goods is a contract whereby seller transfers or agrees to transfer what? A property in the goods to whom? Buyer. For what? Price. That is called as contract of sale. Okay, yes. A contract of sale may be absolute or conditionals. So the sale contract can be either absolute without conditions or it can be with conditions. And in case of sale, there must be what? Transfer of property. When the contract is made, at that time itself, if the ownership is transferred from seller to buyer, it is called as what? Sale. When the ownership is to be transferred on a future date, that is after the contract is made or after the payment of price or after the fulfillment of certain conditions, that is called as agreement to sell. Okay, an agreement to sell becomes a sale when the time elapses or the conditions are fulfilled. That is when the ownership is transferred. That is what becomes a sale. And one more essential of a sale is there should be a transfer of ownership for a price. Without a price, there can't be a transfer of ownership. There can't be a barter system. See, barter system means when you exchange a goods for a goods without measuring it in terms of money. The moment you measure something, a goods in terms of money, it is not called as barter system. For example, when company issues shares worth of 1 lakh to buy machinery worth of 1 lakh, it is not called as barter system. Why? Because both the goods are measured in terms of what? Money. So you are not exchanging shares for machinery here. You are exchanging a machinery worth of 1 lakh measured in terms of money for shares worth of 1 lakh. Because they are measured in terms of money, it is not called as barter system. Okay. Difference between sale and agreement to sell. A transfer of property. Property here means ownership. In case of sale, it is transferred when? Immediately. That is when the contract is made, that time itself. But in case of agreement to sell, the ownership is transferred on a what date? On a future date or a subject to fulfillment of certain conditions. For example, I sell goods to you with a condition that you should make the payment of 1 lakh, then only ownership is transferred. The goods are delivered to you, but contract is also made. But what is not transferred? Ownership is not transferred, because it will be transferred only after you fulfill that specified conditions. Type of contract. This one is an executed contract, means the party's obligation is performed when the contract is made. Agreement to sell is what contract? Executory, because the ownership is transferred on a future date. Types of goods. Sales takes place only in the existing and specific goods, because there is an immediate transfer of ownership. Agreement to sell takes place in case of what goods? Future and contingent goods. Risk of loss. Keep this in mind. The risk of loss always goes with what? Ownership. Whoever is the owner should bear the risk of loss. If seller is the owner, he should take the risk of loss. If buyer is the owner, he should take the risk of loss, irrespective of possession of the goods. Whoever has the ownership should bear the risk of loss. Seller sold the goods. After sale, if something happens to the goods, who will be responsible? Buyer, because who is the owner? See, in case of sale, it is the buyer who becomes the owner immediately after the contract is made. But agreement is still who is the owner? Seller, because ownership is transferred on what date? On a future date. So in case of sale, the ownership is transferred immediately and the risk is also transferred immediately along with ownership. So if something happens to the goods, who will be responsible? Buyer. Whether the goods are with seller or buyer doesn't matter. Once ownership is transferred, whoever is the owner should bear the risk of loss. In case of sale, who is the owner? Buyer is the owner. So once sale happens, buyer becomes the owner, so buyer is responsible. But in case of agreement to sell, even though agreement is made, still who is the owner? Seller is the owner. If the goods are destroyed, who will be responsible? Seller only responsible. Okay. For example, you purchased a mobile phone. You purchased what? Mobile phone. Payment is made. And while carrying the mobile phone, you drop it and it is damaged. Who is responsible? Buyer only responsible, because it is a sale of what goods? Specific goods. Ownership is transferred immediately. But what if it is an agreement to sell? He made an agreement to manufacture and sell 100 chairs. But while manufacturing, chairs are destroyed. He made a promise to grow sugar cane, and but it got destroyed by fire. Now who is responsible? Seller only responsible. Why? Because ownership is not transferred in case of agreement to sell. Keep this in mind. So a risk of loss. Sale, buyer has a risk of loss, and in case of agreement to sell, who has a risk of loss? The seller has a risk of loss. Why? Because still seller is the owner. Breach of contract. If the buyer breached the contract, means he purchased the goods but he is not making the payment. Now seller can sue for what? Price, because ownership is already transferred to the buyer. But in case of agreement to sell, ownership is not transferred. Still seller has the goods. He can resell it to somebody. The only remedy he has is he can recover only the damages. For example, X made a contract agreement with Y to sell 100 chairs. Manufacture and sell 100 chairs. He will manufacture plus he will sell at what price? Let's say 120 rupees. But now what happened? Y refused to accept the goods. Because he refused to accept the goods, X resold the same in the market at 100 rupees. Tell me, what is the loss he suffered because of breach of contract by the buyer? 20 rupees. Correct, right? Y agreed to buy at 120 because Y did not buy. The same goods are sold by X in the market at what price? 100 rupees. Now who can recover this 100 rupees? X can recover 100 from the whom? Mr. Y. Okay, but he can't recover the entire price. Why? Because the ownership is not transferred in case of agreement to sell. General and particular property. See, in case of general property, in case of sale, all the rights of the goods are transferred to whom? Buyer. So it becomes buyer goods, and buyer can file a case against anybody for recovery of his goods, protecting his goods, because he is the owner. Who is the owner? Buyer is the owner. But in case of agreement to sell, still who is the owner? Seller is the owner, not the buyer. So it does not give a right of rem or right in general. The only remedy the buyer has is he can file a case against whom? Seller, not against anybody. See, once sale happens, let's say I sold the goods to you. After I sold the goods to you, delivery is not done, ownership is transferred. If I sell the same to somebody else, can recover the goods? Yes, because you are the owner. But in case of agreement to sell, I made an agreement to sell it to you and goods are with me. Still who is the owner? Seller. Can I sell it to somebody else? Yes, he becomes the true owner. You can't take goods from him. Only you can file a case against me for recovery of compensation. Because a sale creates bundle of rights for you, means that goods belongs to you because you are the owner. You can take action against anybody. But in case of agreement to sell, still who is the owner? Seller is the owner. That is why you can't sue to recover against any person. You can only file a case against whom? Seller. Important last two concepts. Insolvency of the buyer and insolvency of the seller. If buyer becomes insolvent, what would happen? And seller becomes the insolvent, what will happen? Listen carefully. First scenario, sale. And who becomes insolvent? Buyer becomes insolvent. And in case of agreement to sell. In case of sale, who is the owner? Buyer is the owner. In case of agreement to sell, after the agreement is made, who is the owner? Still seller is the owner, unless until the time elapses or unless that condition is fulfilled, still who is the owner? Seller is the owner. Okay, sale and agreement to sell. Now, let's say sale happened. X made a contract with Y. He sold the goods. Sold goods to whom? Y. But goods are not delivered. Goods are not delivered. Goods are not delivered. Okay. And after that, Y becomes insolvent. If Y becomes insolvent, obviously Y will be appointed with what? Official receiver. Court will appoint an official receiver to sell the assets of the Y and to fulfill the liabilities. Now the question is, price is also not paid. What is not paid? Price of 2 lakh not paid. 2 lakh rupees is not paid. Now listen carefully. X sold the goods to whom? Y at a price of 2 lakh. Before Y makes the payment, Y has become insolvent. Means he don't have a sufficient assets to pay for it. Now the question is, can X take back the goods? No, because goods already belongs to whom? Y. Now even X will be considered as what? Considered as unsecured creditor. He should get a ratable dividend. And a simple, guys. I will explain with one more example. Listen carefully. Okay, listen. X, Y. Y has a loan. He has taken a loan from Z 1 lakh, from A 1 lakh, from A 1 lakh. Now after this, what happened? X sold goods worth of how much? 2 lakh on a credit basis. On a credit basis. Now Y defaults. He defaults in the payment of money and he claims insolvency. Once he claims insolvency, what happens is the court will appoint an official receiver to list out the assets of Y and to list out the liabilities of Y and to sell it in the market. Now Y has these things. He has goods worth of only, let's say, worth of 2 lakh rupees. Now the question is, can X go and recover these goods? No, because that goods belongs to whom? Y. And who is the owner? Y is the owner. Because Y is the owner, X cannot recover the goods back. Then what else he can do, sir? Now X, Z, A, all three are considered as unsecured creditors. What creditors? Unsecured creditor. All three of them will get only what dividend? Ratable dividend. Means this 2 lakh will be divided proportionally to whom? To the X, Z and A. X debt is 2, Y debt is, Z debt is 1, A debt is 1. So it will be 2:1:1 is the ratio in which this 2 lakh rupees will be distributed. Because who is the owner? Y is the owner. Seller is considered as unsecured creditor. But what if in case of agreement to sell? Let's take a scenario where agreement to sell happens and buyer becomes insolvent. Agreement to sell. X made a contract with Y where he delivered the goods. He agreed to sell the goods with a condition that ownership will be transferred on payment of what? Money. How much money it is? 2 lakh. 2 lakh on what basis? Credit basis. And he also have a loan from Mr. Z and loan from whom? To Mr. A. 1 lakh rupees loan from Mr. Z, 1 lakh rupees loan from Mr. A. Now what happens? Y defaults. Who defaults? Y defaults. The goods of Mr. X are with whom? Y. Now the question is, can X go and take back the goods? The answer is yes. He is secured creditor. Why is secured creditor, sir? Because ownership is not transferred. Still, who is the owner? X is the owner. Why, sir? Because it is an agreement to sell. Because X is the owner, what X can do? X can recover the goods back. X can recover the goods back. From whom? Goods back from Mr. Y. From Mr. Y. Because in this case ownership is not transferred. Keep this in mind. If ownership is transferred to the buyer and buyer becomes insolvent, seller cannot take back the goods because he is no more the owner. The only thing he has, he is considered as unsecured creditor. He will get a radiable dividend if there is any assets of insolvent person. But in case of agreement to sell, because still seller is the owner, he can take back the goods and he will be considered as secured creditor. Okay, these are the provision with respect to what? Insolvency of a buyer. Insolvency of whom? Buyer. Please, let's go to the insolvency of buyer. In the absence of a lien over the goods, the seller is to return the goods in the official receiver or assignee. He is entitled to get the dividend declared by the official receiver, which will be at reduced rate, means proportionate amount. The seller is not bound to part the goods, means he can take back the goods and not bound to deliver the goods to the buyer, because still who is the owner? Seller is the owner. Insolvency of seller. In case of sale happens, who is the owner? Buyer is the owner. Now buyer can take back goods from whom? Seller, because seller is ownership already transferred to the buyer. But in case of agreement to sell, can buyer recover the goods? No. He will also be considered as what? Unsecured creditor. He will also get a ratiable dividend. What dividend? Ratiable dividend. These are the difference between sale and agreement to sell. Section number 4. Section number 5 provides the provision with respect to how the contract of sale is made. The formalities of contract. See, every contract of sale comes into an existence when one person offered to sell or offered to buy, and the same is accepted by other person. So when one person offered to buy or offered to sell and the other person accept to buy or accept to sell, there is a contract of what? Sale. And in that contract of sale, the parties may agree that there can be immediate delivery of goods, or the delivery of goods is done on a future date, or there can be immediate payment of price, or both may be concurrent. What is concurrent? Made at the same time. Or they can be postponed to a future date. Let's say I made a contract today saying that I will deliver the goods after 10 days, and you will say you will make a payment after 15 days. Here both delivery and payment is postponed to what date? Future date. It is other than the contract date. Is it allowed, sir? Yes, allowed. Okay, it is left to the parties. They can agree any term in the contract of sale. It can be like immediate delivery of goods or immediate payment of money, or both can be postponed to a future date, or it can be like immediate payment but delivery will happen on future date. Or the parties may also agree that the delivery of the goods will happen on installment basis. For example, newspaper, milk, you make payment once, delivery happens installment wise. That is also considered as what? Sale. It is left to the parties to decide as per their convenience the terms of the contract of sale. That is how the contract of sale is made. Section number 5. Remember this. Section number 5 provides how the contract of sale is made. A contract of sale is made when one person offered to sell or offered to buy, other person accept to buy or accept to sell. And these contract of sale may be subjected to immediate payment or immediate delivery, or both can happen concurrently, or it can happen on what basis? Installment basis. Okay, yes. For this purpose, there are various things which are defined in section number 2, that is seller, buyer, all these things are already discussed. Existing goods, future goods, and document of title to the goods, means which indicates the ownership. See, there are two types of documents. Document of title, document showing title. If you can transfer the right to receive the goods by delivering a document, it is called as document of title to the goods. And if you cannot deliver the right, or you cannot transfer the right by delivery of document, it is called as document showing title. For example, property papers. Property papers depicts who is the owner, but you can't transfer the ownership by delivery of the documents. You need to enter into a separate contract. But in case of currency notes, it's a document of title, because if it is with me, I am the owner. If it is with you, you are the owner. In the same way, this warehouse keeper certificate, dock warrant, bill of lading, wharfinger certificate, railway receipt, all these are considered as what? Document of title. Means you can just transfer the right to receive the goods from one person to another person by clear endorsement or delivery. Same like check. If your name is mentioned in check, you can receive it, and if it is endorsed to somebody else, he can receive it. Okay? Yes. Essential conditions of contract of sale. There should be minimum how many parties? 2 parties. Who are those 2 parties? Seller and buyer. The other essential element is there must be a transfer of ownership. What is ownership here? Property. A general ownership means all the right must be transferred. Okay? Yes. Definition of goods, section number 2, subsection 7. Definition of goods I discussed. It means all kind of what property, movable property other than actionable claim and money, but includes stock, shades, growing crops, grass and things attached to or forming part of the land. Okay, and to be a valid contract of sale, there must be transfer of what? Ownership. Transfer of what? Ownership. Section number 5 mandates that a contract of sale may be made by an offer and corresponding acceptance. That is section number 5. Example: Miss Annie asked her class of 60 students that whoever wanted to buy her books may keep 100 on her desk by 3 p.m. with their name slip. This act of students keeping the money on Mrs. Annie's desk with their name slips was implied acceptance of Annie's offer, resulting into what? Binding contract. Correct, right? So there was an offer to sell, another person accepted to buy it by fulfilling the conditions. Then there is a contract of sale. Okay, yes. Section number 6 and section number 7 deals with what? Deals with perishment of goods. Perishment of what? Goods. Perishment of goods. Okay, section number 6. Section number 6 of the Act provides what is the subject matter of contract of sale. What is the purpose of the contract of sale? Obvious, to sell what? Goods. And these goods can be existing goods, future goods, or it can be a contingent goods. Section number 6 of the Act states that goods which form the subject of a contract of a sale may be either existing, owned or possessed by the seller or future goods. There may be a contract for the sale of goods, the acquisition of which by the seller depends upon a contingency which may or may not happen. Nothing but contingent goods. Okay, but the subject matter of the contract of sale is always an existing good or a future goods or the contingent good. It is always the goods, not the immovable properties. Okay. Ramcharan, example, Ramcharan, a merchant, contracted with Bolu, a potato farmer, in January to buy potatoes in June. So contract is made in January to purchase potatoes in June. Tell me, is it a sale or agreement to sell? Who will answer? Is it a sale or agreement to sell? When the contract was made on January, very good, agreement to sell. Agreement to what? Sell. Okay, yes. Now this one, agreement to sell, because it is a sale of what goods? A future goods. However, section number 7 of the Act states that where there is a contract for the sale of specific goods, the contract is void if the goods without the knowledge of the seller have at the time of the contract was made perished or become so damaged so no longer to answer to their description in the contract. Means, let's say I made a contract Section number 7 provides the provision with respect to perishment of goods. Now what is perishing? Perishing means destruction or loss of value of the goods. All are called as perishment. Okay. If I enter into a contract with you, you can to sell, let's say 100 kg of rice which is in my godown. But without my knowledge, that rice is stolen by somebody. Before I made a contract with you, somebody has stolen it. It is not in existence, but I believe it is in existence. So believing that the goods is in existence, I made a contract with you. Is this contract valid? No, the contract is void. Why? Because the goods are not in existence. So simple, correct. If the goods are destroyed before the contract is made, it is called as what? Void contract. Okay. Now, so what if an agreement is made? Let's say I made an agreement with you to manufacture and sell 100 chairs. While manufacturing, goods are destroyed. Who will be responsible? Seller or buyer? Seller. Very good. Awesome. Because ownership is not transferred. Again, agreement becomes void. Okay. Now, I'll give an example to you. You should tell me what happens in this case. Let's say I made a contract with you to manufacture and sell pani puri. Puri aata hai na? That puri which is used for selling pani puri. Okay. So I made a contract to sell 1000 puris. I made a contract to manufacture or make 1000 puris and sell it to you. I made the puris, but before I transfer it to you, before the ownership is transferred, what happened? That puris are destroyed, means they are crushed. So that it is no longer called as puri, means it is all smashed. It is smashed into pieces by fall of something on it or because of some reasons. Now, is the goods are in the same description which was made when the contract was made? No. See, that goods can be still used for some other purpose, correct? Now that puri can be used for what? To make masala puri, but not for pani puri, correct, right? So because it is no longer answerable to the description was made earlier, now the agreement becomes what? Void. Are you bound to accept these goods? I made an agreement to make puris and sell it to you. I made puris, but something fell on it, it is destroyed. Destroyed in the sense it is crushed. Now I will say somehow adjust karo, take these puris. Are you bound to take it or not bound to take it if you are a buyer? No, because it is not answerable to description made, right? What is the description made? Puris, but not the crushed one. In the same way, when I made a contract, if I make a contract to sell dates to you, but the dates are rotten or it is perished, that you can't consume it directly, but you can make wine out of it. Out of the dates you can make what? Wine, but you cannot consume it. So now, are you bound to accept these dates which are rotten? No, because when a contract was made, I made a contract to sell what? Dates, not the rotten date, correct, right? Yes. So if the goods are destroyed before the ownership is transferred, that is before agreement or after agreement, but before transfer of ownership, the agreement becomes void, and only who is responsible? Seller is responsible. Okay. Mahesh asked his friend Rakesh to deliver 40 kilograms of mangoes for manufacturing mango jam. This delivery to be made to Mahesh in the next 2 months. However, due to bad climatic conditions, the mangoes that were ripe and are ready to be plucked got spoiled. So, and were no longer in a state to be delivered for manufacturing jam. So, is it agreement valid? No, the agreement is void and the goods are destroyed or perished before the contract is made. Okay, yes. Section number 8. Section number 8 provides the provision with respect to fixation of price. 8 and 9 deals with what? Fixation of price. Okay. Where there is an agreement for sale of specific goods and subsequently the goods without any fault on the part of the seller or buyer perish or become so damaged no longer to be answerable to their description in the agreement, before the risk passes to the buyer, agreement is thereby avoided, means it becomes void, correct now? Because before transfer of ownership, if something happens to the goods, the agreement becomes void. Next one, fixing the price of the contract in a sale for every contract of sale. Section number 9 of the Act talks about ascertainment of price, which states that price in a contract of sale has to be fixed by the contract itself. Let's say I am entering into a contract with you. We will agree what? Let's say 1 lakh rupees is the price. That is the price, whatever agreed in the contract. Or be fixed in a manner agreed between the parties. Means whatever the manner which the parties agrees. As per that manner. For example, let's say I made a contract with you with a condition that the price will be fixed as per the market price, or the price will be the cost plus 10% of profit. So we are not agreeing the exact price here, we are agreeing the manner of fixing the price. So both are considered as what? Valid. Are determined by the course of dealing. There are 3 ways. One is we can agree in the contract itself, or we can agree that fixation of manner of fixing the price in the contract of sale, or we can agree to fix the price as per the course of dealing, means the transactions we make between us. Okay. However, the same provision suggests that to the situations where the price has not been fixed. In such a cases, the buyer shall pay the seller a reasonable price. What price? Reasonable price. When the price cannot be ascertained, means in the 3 ways, if the price is cannot be ascertained. What is the first way? The first way is it can be agreed in the contract itself. Second one is it can be parties can agree the manner of fixing the price, or based upon their course of dealing, usually at what price they sell. If the price cannot be ascertained in none of these ways, then the law provides the buyer must pay what price? Reasonable price. And what is reasonable price is a question of fact. Okay, yes. A and B have a contract between them to perform the respective promises. A promised to sell to B his car. In return, B promised to pay 1 lakh for the same. So here the price is fixed where? Contract itself. That is the price of the goods. Okay. However, there may be situation. Section number 10 provides provision with respect to fixation of price at a valuation done by a third party. This is a one more area where CMA can practice, or CA can practice, or a CS can practice. So once you become a CMA, there is a course called as valuation course, where it's a separate course or a separate degree for getting an expertise knowledge in valuation of few things. For example, valuation of goodwill, valuation of shares, valuation of properties, because that requires certain set of skills, or valuation of jewelry items. So now if I enter into a contract with you to sell my company shares subject to the price fixed by a valuer, that is my CA or a CMA, then the price of the goods depends upon what? The price fixed by the CA or CMA. So if the CA says 1 lakh, that is the price of the goods. If he said 2 lakh, that is the price of the goods at which I am bound to sell it to you, you are bound to purchase it. That is called as sale of goods at a price or a valuation done by a third party. So in this scenario where there is a contract to sell the goods at a price fixed by a third party, in these cases, if a third party fixes the price, the contract is valid. If it does not fix the price, the contract becomes what? Void. Let's say X made a contract with whom? Y, where they have made a contract, and this contract it is agreed that, what is agreed here? That the price will be fixed by whom? Z. Now in this scenario, if Z fixes the price, the contract becomes what? Valid. Z fixes the price, contract becomes valid. If it does not fix the price, the contract becomes what? Void. If one party prevents, let's say Y prevents Z from fixing the price, then Y shall compensate X. Contract is still void, but Y shall compensate whom? X. Or if X prevents Z from fixing the price, then X shall compensate whom? Y. Whoever prevents the third party from fixing the price, such person shall compensate the other party. Okay, so this is about the fixation of price at a valuation done by whom? By a valuer. Valuation done by whom? Done by a valuer. Okay. Yes. Yeah. Next one. Section number 11. Section number क्या है? 11. I hope you guys thoroughly understood the Section number 1 to section number 10. Okay, I repeat for you guys the list of section numbers. You can note it down if you want to. Section number 1 provides short title, extent, commencement and commencement. Section number 2 provides the definitions, which I have discussed already. The definition of goods, definition of the buyer and seller, definition of mercantile agent, definition of types of goods, all these things. Okay, section number 3 is not relevant. Section number 4 provides the definition of contract of sale. Contract of sale, correct na? Contract of sale. Section number 5 provides how the contract of sale is made. Section number 6 provides the provision with respect to perishment of goods, sorry, subject matter of contract of sale. What is the subject matter of contract of sale? It is the goods. It can be existing goods, future goods or contingent goods. Section number 7 and 8 deals with perishment of goods. What happens if the goods are perished? Before agreement, 8 is after agreement. Section number 9 provides fixation of price, how the price of the contract, how the price of the goods are fixed in a contract of sale. Section number 10 provides what? Section number 10 provides the fixation of price at what? At a valuations. Fixation of price at a valuation done by whom? By the valuer. Section number 11 provides what? Section number 11 provides the provision with respect to. 11 provides the provision with respect to what? Stipulation as to time. Stipulation as to what? As to time. Stipulation as to time. Okay, so let us start with section number 11. Now, what is stipulation? Stipulations are nothing but terms in the contract. Terms in the contract. So, see, there is a presumption by law. There is what? Presumption by the law. In case of sale of goods, there is a presumption. What is presumptions are? Assumptions. Presumes. There is a presumption by a law. What is the presumption by law? The presumption by the law is that in case of goods, in case of what? Goods. Sorry, sale of goods. A contract for sale of goods. A contract for sale of goods. Contract of sale of goods. For delivery of goods. For what? Delivery of goods. For delivery of goods and for payment of money. For payment of price. For payment of price. For delivery of goods and payment of price. The law provides that for delivery of goods, what is important? Time is the essence. Time is the essence. Means what? Time is so important. You should deliver the goods on an agreed date or agreed time. If the goods are not delivered on the agreed time, because time is in essence, if not delivered on time, what buyer can do? Buyer can resign the contract. He has an option to cancel it. What is resign? Cancel. He has a right to cancel and he can sue for damages, because time is most important in case of delivery of goods. But for payment of price, no, time is not the essence. That is what law says. But parties can change this, okay? The parties by an agreement, they can change this presumption by law. So what is the presumption by law? The law says for delivery of goods, what is important? Time is important. But for payment of money, time is not important. But this can be changed by what? Agreement between the parties. For payment of price, time is not the essence. Means time is not important. Because time is not the essence, if the payment is not done on time, payment not done on time or an agreed time. So in this case, what can be done? In this case, if the payment is not done on time, the seller cannot resign. The seller cannot resign the contract. Means he cannot cancel it. The only remedy he has, he can recover the compensation, that is damages, in the form of interest. He can recover in the form of what? In the form of interest. Okay, that's it. But he can't claim, he cannot cancel the contract. Okay, now let me give an example. Let's say I made a contract to deliver the goods worth of 1000 kg on 13th of February. If I don't deliver on 13th, what buyer can do? He can cancel the contract, because time is important in case of what? Delivery of goods. But what if you have agreed to pay the money on 13th and I agreed to deliver the goods on 15th? You fail to make the payment on 13th. Can I cancel the contract immediately? No, I have to wait till what time? 15th. I should give a notice to you saying that if you don't make the payment, I will resell it to somebody. After giving notice also, if you don't make payment, then I can resell it. Because time is not the essence for what? Payment of money. Okay. So, if payment is not done on time, can seller cancel the contract? No. But if the delivery is not done on time, can buyer cancel the contract? Yes, because time is important in case of delivery of goods. Sir, can parties change these terms, sir? Yes, they can change it. By what? Agreement. What if in this contract they have agreed that even for payment of money, time is important? So, because it is clearly agreed that even for payment of money, time is important, then the payment should be done on time. Otherwise, the seller can cancel it. If nothing is agreed, this is a presumption. You should go with the presumption of law. If agreement is silent, what presumption of the law is? The law states that for delivery of goods, time is important, but for payment of money, time is not important. Clear? Section number 11. Okay, yes. Section number 11 states that unless a different intention appears from the terms of the contract, means there is nothing agreed by the parties, agreement is silent, then stipulations, that is time as to time of payment, are not deemed to be the essence of contract. For payment, it is not the essence, but for delivery of goods, it is considered as what? Considered as essence of the contract. Okay, if the delivery is not done on time, then what happens? What happens? If the delivery is not done on time, can buyer cancel it? Yes or no? Yes, but if the payment is not done on time, can seller cancel it? No. Very good. Okay, yes. Next, let us discuss section number 12. Section number 12 and 13 deals with conditions and warranties. Okay, section number 12. Now, first of all, what is this conditions and warranties? Listen carefully. These are nothing but stipulations. These are nothing but what? Stipulations. Now, what are stipulations, sir? Stipulations are nothing but terms. In the law language, we call the terms as what? Stipulations. Okay. So, whatever the terms agreed by the parties in a contract of sale are called as stipulations. And that stipulations can be either conditions or it can be warranties. Okay. Now, let us understand what are conditions and what are warranties. Okay. Let's take an example. With the example, we will understand this concept of conditions and warranties. Let's say Mr. X is entering into a contract with Y. X is the showroom owner. He has a car showroom, and Y is the buyer. Okay, so both will agree something, correct, right? Now Y want to buy a black color car, black color SUV, Mahindra SUV 800. He want to purchase this car which has a speed of, let's say, 300 kilometers per hour kmph, and gives a mileage of, let's say 10 kilometers per liter of petrol, then it also has mileage ho gaya, then it has the airbag. This is the representation made by showroom person and Y. Both are agreeing this in the contract of sale. It comes with an airbag. It has a sound system, inbuilt sound system. inbuilt sound system. It also has AC, air conditioner, inbuilt air conditioner. It will have mirrors, it will have tires, it will have something else. All these things are there in the car, correct, right? Yes. These are all part of what? Contract. Everything whatever agreed by the parties in a contract of sale are called as what? These are called as what? Called as stipulations. These terms are called as what? Stipulations. Called as stipulations. Okay, yes. Now out of all these stipulations, all are not that equally important, correct, right? Some are more important in this contract, some are less important, correct, right? If you take our body, in this body some organs are most important, without that we can't function. Some are important, but if those things are not there, still we can function, still we can be alive. For example, heart is the most important thing. Fingers are not the most important. If you lose your finger, will you die? No. So the fingers are like warranties, heart is like condition. This entire bodies, whatever we have, they are called as stipulations. In a contract, body is like contract. Whatever the things we have, organs we have, is called as what? Stipulations. In that stipulations, whatever are most important, out of these stipulations, whatever is most essential, or whatever the things which are essential to the main purpose of the contract, to the main purpose of the contract, main purpose of the contract are called as what? Conditions. Are called as conditions. The stipulations which are collateral to the main purpose of the contract, to the main purpose of the contract, is called as what? Called as warranty. Warranty. Collateral means supportive, not that so important. Whatever is essential, most important, is called as conditions. Whatever is not so important, they are just supportive, collateral, they are called as a warranty. Okay. Now, breach of conditions. If we lose our heart, if our heart stops functioning, what happens? Death happens. In the same way, a breach of conditions gives the buyer, if there is a breach of condition, buyer gets how many options? 2 options. He gets 2 remedies. What are the 2 remedies? He can resign the contract. Who can resign the contract? The buyer can resign the contract, plus he can also sue for what? Damages, the compensation. Who can resign? The buyer can resign, plus he can also file a case for damages. He has 2 options. If there is a breach of conditions, means non-fulfillment of condition promised by the seller, then the buyer can cancel the contract, means he can reject the goods, plus he can file a case for damages. But because warranties are not so important, a breach of warranty gives the buyer how many remedies? Buyer has an remedy only to what? Claim the damages. Only to claim what? Damages, the compensation. Okay, this is what called as conditions and warranties. I repeat, out of so many stipulations in a contract of sale, there may be few which are most important, there may be few which are not so important, that is collateral. Whatever are important, are essentials, they are called as conditions. Whatever the stipulations which are not so important, they are just supportive or a part of it, they are called as collateral to the main purpose of the contract, they are called as warranties. A breach or non-fulfillment of conditions gives 2 remedies. One is to resign the contract and to claim the damages, and a collateral in case of breach of any warranty gives how many remedies to the buyer? Only 1 remedy, that is to claim the damages. Okay, yes. Now in this example, whatever I gave the examples, you guys should tell me which one is condition, which one is warranty, which one is so important here. First one, color. Is it important? Instead of giving the black color, if the car showroom person gives a white color car, can you reject the car and sue for damages if you have suffered any loss? Yes, so that is considered as what? Condition. Most important. Is speed is important? Obviously yes, condition hai. Mileage is important? Yes. What if it is giving a mileage of 1 kilometers per liter? Condition. Airbag is important? If there is any problem with the airbag, yes, it is the condition. Sound system, let's say there is a small damage to the sound system. Can you reject the entire car? Can you say, I don't want this car, give me a new car? No, this is considered as what? Warranty. Same thing in case of AC system, there is a problem. It's considered as what? Warranty. Correct, right? Yes. Now what if one mirror is damaged? There is a mirror, side mirrors, a rear view mirror, left side mirror is damaged. Can you reject the car itself, or you can only get it repaired or get a compensation? Get a what? Compensation. So mirror is considered as what? Warranty. Okay, so now you got an idea of like how to differentiate conditions and warranties, right? The stipulations which are most important, they are called as what? Conditions. The stipulations which are not so important, they're just collateral or supportive to the main purpose, are called as what? Called as what? Warranties. A breach of condition gives how many remedies? 2 remedies. A breach of warranty gives awesome. The breach of warranty gives only how many remedies? 1 remedy. What is that 1 remedy? You can only claim compensation. But breach of conditions gives 2 remedies. You have the option to cancel it and you can claim the compensation also. Okay? Yes, very good. Let's start with conditions and warranties. What are conditions? Condition is a stipulation which is essential to the main purpose of the contract. That is, that is the main purpose of the contract. That is the most important thing. That is called as what? Conditions. A stipulation which is essential to the main purpose of the contract, the breach of which gives rise to the right to treat the contract as repudiated. What is repudiated? Cancelled. So the buyer has a right to cancel it. That is called as breach of conditions. Okay, it's a fundamental nature of breach of which buyer can repudiate the contract. Ramesh is the landlord who rents out his house to tenants. He put it down in the rental agreement that all tenants have to pay the rent upfront in cash and not in checks or bank transfer and so on. This was because Ramesh thought the checks and other instruments were subject to clearing and he needed the money upfront on the first day on every month with this mandatory condition. Ramesh added that any diversion from this method of payment would lead to repudiation of the contract. So because it is clearly mentioned that it is an important thing, it is considered as conditions and they can repudiate the contract. Okay, warranty, a stipulation, the collateral to the main purpose. Collateral to what? Main purpose of the contract are called as warranties. Okay, this is not so important. This is a part of the contract. It is also a stipulation but not so important. And a breach of warranty gives only a right to claim compensation but not to cancel it. Okay, example, Standard Oil Company entered into a contract with XYZ petrol pump for supply of 1000 liters of petrol over 1 year period. Therefore, Standard Oil decided to continuously sell the petrol in installment over the 1 year. However, at the end of the year, it was found only 800 liters were supplied and the remaining 200 liters of petrol was denied by the petrol pump as there was no sale. Standard Oil now can claim what? Damages, because it is not considered as a important thing. Okay, yes. Difference between conditions and warranties that you can around make it out. Conditions are essential to the main purpose of the contract. Warranties are collateral to the main purpose of the contract. Conditions, the aggrieved party can cancel the contract. Warranties, you can only claim what? Damages. A breach of condition may be considered as what? A breach of warranty. Means because condition gives two rights. You can keep that right to claim compensation and you can give up that right to cancel it. For example, you ordered a black car but he delivered white car. Now you're okay with it. If you're okay with it, instead of cancelling it, what you can do, keep the car and you can only claim compensation if you have suffered any loss. Now you are treating your breach of condition as what? Breach of warranty. In the same way, a breach of warranty cannot be considered as what? Breach of conditions, because you have only one remedy. What is that one remedy? To claim compensation. You can't cancel it. Okay, yes. So breach of condition can be considered as breach of warranty, but a breach of warranty cannot be considered as breach of conditions. Okay, yes. Next, when condition to be treated as warranty, section number 13. Section number 13 provides that where a contract of in the sale, in what scenarios a condition should be considered as condition warranty. Listen carefully, important. They may ask this question in the examinations. In what scenarios a breach of condition may be considered as breach of warranty? First one, subject to any condition to be fulfilled by the seller, the buyer may waive the condition. Waive means voluntary give up. If buyer says, I don't want to claim the right to cancel it, I only want to claim the compensation, then a breach of condition is considered as breach of warranty. Or you may elect to treat the breach of condition as what? Breach of warranty. Means he is only electing it. These are both are voluntarily, okay? Means where buyer has an option, he decide to not to cancel it, only to claim the compensation. Because he has decided to not to cancel the contract and he is willing to only accept the compensation, it is considered as a breach of, it becomes breach of warranty, not the condition. Second one, if the contract is not severable and the buyer has accepted the goods or part thereof, if he has accepted the goods, once you accept the goods, you can't cancel it later. So, if the contract is non-severable and the buyer has accepted the goods, in that scenario, a breach of condition becomes breach of warranty. And second one, next one is where the performance of a condition is excused by the law. Excused by what? Law, due to the reason of impossibility, supervening impossibility. In that scenario also, a breach of condition can be considered as a breach of warranty. Okay, I repeat. Generally, a breach of condition gives two remedies. One to cancel, one to claim compensation. But however, the buyer can give up the right to cancel and he can only claim what? Compensation. When the buyer gives up that right, waives or elect to treat the breach of condition as breach of warranty, in both the scenarios, a condition becomes what? A warranty. And where there is a contract which is not severable, which is not separable, in that scenario, the buyer may accept the goods, and when he accepts the goods, in that scenario, the breach of condition becomes what? Breach of warranty. Our last one is where the performance of conditions, for example, let's say today is the date of delivery, but there is a supervening impossibility, COVID-19 or lockdown. That because of that reason, if you could not deliver it, it can be delivered the next day because it is a supervening impossibility excused by law itself. Okay, yes. Remedy for the breach of conditions, I discussed there are how many remedies in case of breach of conditions? Two remedies. For the two remedies, the buyer can cancel and sue for damages. Okay. Consequences for the breach of warranties, there are only how many remedies? One remedy. What is that one remedy? You can only claim the damages. Okay. Section number 13(3). 12 provides the provision with respect to conditions and warranties. Section number 13 provides the scenarios where a breach of conditions can be considered as a breach of warranty. Now, section number 14 से शुरू होता है कि our implied conditions and warranties. See, conditions and warranties can be of two types. What are the two types? Expressed or implied. So whatever we have agreed in the contract, see whatever these things are there, right? We have specifically discussed that mileage, color, whatever the parties agrees in the contract by words, that is called as expressed conditions and warranties. So whatever the parties themselves agree in a contract, they are called as what? Expressed conditions and warranties. Along with those conditions and warranties, there are few conditions and warranties which are deemed to be present in every contract of sale. If I am entering into a contract with you, they presume to be there. They are deemed to be there. So those are the conditions and warranties which are called as implied conditions and warranties. Same like implied rights of the partners, which is not given by the partnership agreement, but still they are deemed to have those rights. In the same way, there are a few conditions and warranties which are part of every contract of sale, whether parties have agreed it or not. Such conditions and warranties are called as implied conditions and warranties. Okay, yes, what is the first one? Condition as to title, section number 14A. Condition as to title. What is title here? Title means ownership. Title means the ownership. So what is this condition as to title, sir? It means in a contract of sale, unless the circumstances of the contract are such as to show a different intention, there is an implied condition on the part of the seller that in case of sale, the seller has a right to sell it, and in case of agreement to sell, he will have a right to sell the goods at the time when the property is to pass. Just keep this in mind. This condition just provide that seller, when you sell, that is when you are transferring ownership, you must be having a right to transfer it, right to have the right to transfer the ownership. If the seller does not have a right to transfer the ownership and makes a contract, then who is not responsible? Then buyer is not responsible. Only who is responsible? Seller is responsible. I repeat, when there is a contract for a sale of goods, when there is an immediate transfer of ownership, then when the contract is made, that time itself the seller shall have a right to sell it, that is right to transfer ownership. But if it is an agreement to sell, law does not require you to be owner at the time of contract. Law just says when you transfer ownership, at that time you shall have a right to sell it, right to transfer it. If you don't have a right to transfer it, but you make a contract to transfer it, that amounts to breach of what? Condition. Condition as to title. Okay. For example, let's say I have a stolen goods. Okay, I have a goods which does not belongs to me. I enter into a contract with you to sell it. Tell me, is there any breach of implied condition here? Yes or no? I have taken somebody's goods and I will sell it to you. Is there any breach of condition here? Yes, very good, because law says when I am selling something, I must have the ownership. Do I have the ownership here? Do I have a right to sell it? No. Because of that, it amounts to breach of conditions. The moment you discover it, what you can do? You can reject the goods and you can also sue me for what? Compensation. Now what if I make an agreement with you today saying that okay, I will purchase this from her and I will sell it to you after 1 month, next month, March. When the contract is made here, am I the owner? No. And the law also does not require me to be owner when the agreement is made. The law requires me to be the owner when I transfer ownership, means when I take the goods from her and I give it to you. If I take it from her forcefully without proper payment and if I give it to you, it amounts to what? Breach of condition. Okay, yes, I'll give one more example for this. Okay, let's say I'm a normal trader. Okay, can I sell milk by using the brand name called as Nandini? Why no? Because it is a registered trademark, correct, right? Yes. It's a registered trademark. Nandini is a registered trademark. I can't use the trademark. It's a violation of their right. They have a right. I don't have a right to use the name called Nandini. But what if I enter into a contract with you to sell 100 liters of Nandini milk without having a right to sell it? I don't have any franchisee. I don't have any permission taken from them. Just I'll manufacture. I'll take the milk from the cows. I'll pack it as Nandini milk and I'll sell it to you. Later you discover that it is not, I'm not the authorized one to sell it, but it is just a packed milk. Tell me, can you reject the milk here? Yes, you can reject it, and you can also sue for what? Compensation. Why? Because there is a breach of condition as to title ownership. Okay, so when the goods are sold by sold, yes, because the ownership is not with me, correct? So when I am selling it, I shall be the owner, means I shall have a right to sell it. When I am agreeing to sell, at the time when the property is to pass from seller to the buyer, I shall have a right to sell it. If I don't have, it amounts to breach of an implied condition. The buyer can reject, plus he can sue for damages. Next one, sale by description. Now what is description? Description means describing a goods based on its qualities, characteristics, or based on the place of origin of the goods. Okay, so when there is a sale by description, there is an implied condition that the good shall correspond with the description, means same as description. Even if the buyer had the opportunity to inspect the goods, still it becomes the duty of the seller to supply the goods as per the description made. If it does not correspond with the description, it amounts to breach of a condition. The buyer can cancel it. For example, let's say you go and ask in the shop to give Nandini butter or Nandini paneer. Instead of giving Nandini paneer, the seller gives Amul paneer. Sir, paneer is both same na sir. Paneer to it will be made out of the cow milk only. So now tell me, is there any breach of condition here? You asked for Nandini paneer, but the person has supplied Amul paneer. Is there any breach of condition here? Yes, because the description was Nandini paneer, but he supplied what? Amul paneer. It is not same as description. So what buyer can do? Cancel, and you can file a case against him for compensation. I'll give one more example. Let's say Kanchivaram sarees. What is Kanchivaram sarees? A saree can be called as Kanchivaram saree only if it is waved. Where? In Kanchivaram, correct, right? Now what if I make a saree in Bangalore? It is waved in, the weaving is happening in Bangalore, and it is sold as Kanchivaram saree. Is it a breach of condition as to sale by description? Yes, because what is the description made? Kanchivaram sarees. So it should be as what? Same as per descriptions. Okay. Yes, I'll give one more example. We can call a rice as basmati rice. We have this is one of the interesting case study. A rice can be called as basmati rice only if it is grown in the Punjab, certain regions of Punjab, and certain places of Pakistan, Sindh province of Pakistan. Why? Because that aroma will come. That aroma out of that rice will come only if it is grown in those parts. And this right to call it as basmati rice is protected by law called as Geographical Indication Act. We have a law where certain things are protected to be called as such only if it is made or produced in that particular places. That is called Geographical Indication Act. For example, laddu, Tirupati laddu. A laddu can be called as Tirupati laddu only if it is made where? In Tirupati Devasthanam, TTD, as per Geographical Indication Act. So, if there is a sale by description, the goods purchased shall correspond with what? Descriptions. If not, the buyer can cancel the contract and they can sue for damages. Next one, condition as to quality or fitness for the buyer purpose. Interesting one, section number 16. See, The law provides that it is the duty of the buyer to make sure that he buy the right quality of goods which is suitable for his purpose. So the buyer should make sure that he purchase the right quality of the goods which is suitable for his purpose. Okay. If the buyer purchase the wrong quality of the goods, who is not responsible? Seller is not responsible. You go to a shop, you want to buy something, then it is your duty to make sure you buy a purchase goods, you buy a right quality of the goods, correct na? Is the seller responsible or bound to give what you are willing to buy? No, because how will he know what you want? That is why the law says let the buyer be aware. The buyer should make sure that he purchases the right quality of the goods which is suitable for his purpose. But there is an exception to this rule. What is the exception, sir? It becomes a duty of seller. Generally, it is not the duty of seller. It is whose duty? Buyer's duty. It becomes the duty of the seller to make sure that he supply the right quality of the goods which is suitable for the buyer purpose only if it satisfies three conditions. What are the three conditions? The first condition is that the buyer should make the seller aware about the purpose for which he need the goods. For which he need what? Goods. Second condition is that the seller should be dealing with the goods in the ordinary course of business. And the third condition is that the buyer should rely upon skill and judgment of seller. Means he should not go with a brand name. He should go with the he should leave it to the seller's decision, saying that you decide what is best for me. When these three conditions are satisfied, in that particular scenario, the burden shifts to seller. Now it becomes the duty of the seller to supply the goods suitable for whose purpose? Buyer purpose. If the buyer has not received the goods suitable for his purpose, means the seller supplied the goods which is not suitable for buyer purpose, in that scenario, then who would be responsible? Buyer will be held seller will be held responsible to compensate the buyer. Means buyer can cancel it and he can sue the seller for compensation. For example, let's say go to a medical store and say, give me a headache tablet. In this case, you made the seller aware about the purpose for which you need the goods. Second thing is you relied upon his skill and judgment. Third thing is that person is dealing with that kind of goods. Now it becomes his duty to make sure that he supplied the right quality of goods to you. If not, you can cancel it. But what if you just go to a medical store and buy a wrong goods? Now who would be responsible? Seller or buyer? You go to a showroom and purchase a wrong goods without inquiring it properly, without intimating the seller the purpose for which you need the goods. Who would be responsible? Buyer or seller? Buyer responsible. Awesome, because you did not specify the purpose for which you need the goods. Next, sale by sample. When the goods are sold by sample, then the law imposes three important conditions. What are they? The first one is that the bulk supplied shall correspond with what? The sample in quality. And the buyer shall have a reasonable opportunity of comparing the bulk with what? Sample. And the goods shall be free from what? Any defect, rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. Means hidden defects. So these are the conditions. What is the condition? In case of sale by sample, there is an implied condition that the bulk supplied should be same as a sample. the buyer should have an opportunity to inspect the bulk and compare them with the sample. And the last one, that the goods supplied shall be free from hidden defect. We also call them latent defects. If any one condition is not satisfied, it amounts to breach of condition. The buyer can cancel the contract, plus he can sue for damages. Okay. Example, David sold Indian variant of sunflower seeds at his shop and sold it in bulk for whoever wanted to buy the same. Tatiana tested the sample of the seeds at David's shop and decided to order it in bulk. However, when David sent the seeds in bulk, Tatiana decided to sow the seeds. Months later, Tatiana discovered that the seeds were of Swedish variant and not the Indian variant. So here, it is same as what is the sample shown? Indian variant, but what is supplied? Swedish variant. Is there any breach of condition here? Is there any breach of condition here? Yes. Now the buyer can cancel the contract and he can sue the seller for what? Recovery of compensation. Okay. Yes. Yes. In case of eatables, last condition is the, in case of eatables, what are eatables? The foodstuffs. There is an implied condition that there should be wholesomeness, means fit for human consumption. If they are not have wholesomeness, the buyer can cancel the contract and sue for damages. When you go to a 5-star hotel, it is implied that they shall supply a good quality food. If the quality of the food is not good, you can cancel and you can sue for damages. Next one, implied warranties. What are implied warranties? As we said, a breach of warranty gives how many remedies? Only one remedy. Section number 14B provides the provision with respect to warranty of quiet possession. What is quiet possession? Simple. See, when you buy something, you must enjoy it peacefully, correct, right? When you purchase a dosa, you should enjoy it peacefully without any disturbances. What if somebody comes and takes it? How do you feel? Terrible feeling, right? In the same way, when you purchase a car, when you purchase a bike, when you purchase something, you become the owner, and the purpose of buying is to enjoy it peacefully without any disturbances. What if you purchase something, but due to the seller fault or due to the seller's defective title, you cannot enjoy it peacefully? You could not enjoy it peacefully. Now, because of this, it amounts to what? Breach of warranty. What you can do? The buyer can file a suit for damages. This quiet possession and also this breach of condition goes hand in hand. If there is a breach of condition as the title, obviously you can cancel the contract, plus you can sue for damages. In the same way, if seller is not the owner and he sells it to you, and because of that there is a disturbance in the possession of the goods, what you can do? You can sue for compensation. Okay. Next one, warranty of freedom from encumbrances. Now, what is encumbrances? A charge. Any charge created over the goods is called as what? Encumbrance. Encumbrances can be of various types. It can be by pledge, it can be by mortgage, it can be by hypothecation. This I have discussed in the bailment chapter itself. When there is a encumbrance on the assets or a goods, the seller cannot sell it. For example, if I have taken a loan on vehicle, unless until I clear the loan or unless until I take a permission of the bank, I can't sell it. If I sell it without the permission of the seller, what buyer can do? Buyer can recover compensation. For example, I have pledged my car to a bank for 1 lakh loan. I sold the same to somebody who is acting in good faith at 2 lakh. Now bank wanted to recover that car because they have a charge over it. Now buyer paid 1 lakh to save that car. Now who can recover? Buyer can recover from the seller. So if a seller sells a car on which there is an encumbrances, in that scenario the buyer can recover compensation from the seller. Next one, warranty has to quality or fitness by usage of trade. Means there are cases where it is implied warranty that whatever the goods supplied should be fit for user consumption. For example, in the dental industry there is a practice that whatever that artificial teeth supplied should fit the human, should fit the particular patient. If not, what patient can do? He can file a suit for compensation. That is warranty as to quality or fitness by usage of trade. What is usage? Practice. If something is a practice in a particular trade or business, those practices must be observed. Next one, warranty to disclose dangerous nature of goods. Important. If the goods are of dangerous nature and if seller is aware about those dangerous nature of the goods, he must intimate the same to whom? Buyer. If not intimated and buyer suffers the loss, then it becomes whose duty? Seller's duty to compensate the buyer. That is why you would have seen in the packets out and in the goods, they usually mention be aware, caution, keep it away from children, because it is mandatory that the seller disclose the dangerous nature of goods. So these are the implied conditions and warranties. Okay, doctrine of caveat emptor, simple. As I said earlier, section number 16 deals with what? Doctrine of caveat emptor. Caveat means caution. In the law language, it is a Latin word. Caveat means what? Caution. Emptor means buyer. So the law provides that it is the buyer who should be cautious or who should be careful or aware. So let the buyer be aware. It is a duty. It is a buyer who should make sure that he will be careful enough when he purchases the goods. If he is not careful and if he purchases the wrong goods, then who will be responsible? Buyer only responsible, not the seller. Okay, I repeat, it is not the duty of the seller to supply the goods suitable for the buyer purpose. Then it is whose duty, sir? It is the buyer's duty. Buyer should make sure that he purchases the right quality of the goods which is suitable for his purpose. If by mistake buyer purchase the wrong quality of the goods which is not suitable for his purpose, then who is responsible? Buyer only responsible, not the seller. Okay, it was applied in the case of Ward versus Hobbs, where the person was selling the pigs with a board with a caution that these pigs are sold with all the fault or error. Means I am selling it with all the faults in it. If you want, you can inquire it properly, check it properly, then you purchase it. But the buyer purchased the pigs without proper inspection. So it is whose fault? Buyer fault. He purchased it. The pigs were suffering from swine flu. He kept the pigs with his own pigs. All the pigs were dead. Now who is responsible? Buyer or seller? Buyer only responsible, because caveat emptor. Let the buyer be aware. Okay, but however there are exceptional cases where it becomes whose responsibility? Seller's responsibility to supply the goods suitable for whose purpose? Buyer purpose. When first one is condition as to quality or fitness for buyer purpose, means when buyer makes the seller aware about the purpose for which he need the goods, and he also relies upon skill and judgment of the seller, and seller regularly act in that kind of goods. In this scenario, it is whose duty? Seller's duty to supply the goods suitable for whose purpose? Buyer purpose. If not, who can cancel the contract? buyer can cancel the contract. Okay, generally it is a duty of the buyer to purchase the goods suitable for his purpose. If the buyer makes the seller aware about the purpose for which he needs the goods and he relies upon the seller's skill and judgment, then it becomes the duty of the seller to supply the right quality of goods suitable for buyer purpose. If not, buyer can rescind the contract, sue for damages. Next one, where goods are bought by description from the seller who deals in the goods of the description. So in case of sale of goods by description, it is a duty of the seller to supply the goods as described. If not, then what buyer can do? Cancel it and sue for damages. Okay. Next one, merchantability means that commercial value which is known in the market. Next, there is an implied warranty or a condition or quality or fitness for a particular purpose annexed by usage of trade. When I gave an example of this dental example, if something is a practice or a custom which is similarly followed again and again in a particular scenario or situation, that also required to be followed. Next one, an express warranty or condition does not negative a warranty or condition implied by this act unless inconsistent therewith. Means, for example, if there is a sale by sample, sale by sample as well as descriptions, or in case of fraud, in these cases the principle of caveat emptor is not applicable. Section number 16. Okay, so we discussed section number 12, 13, 14, 15 and 16, implied conditions and warranties, and also caveat emptor. What is caveat emptor? Let the buyer be aware. Okay, next we have transfer of ownership. Okay, transfer of what? Ownership. 18 to 26. See, transfer of ownership. What is ownership? The property in the goods. Ascertaining at what point of time ownership is transferred from one person to another person is most important. Now you can ask me questions, sir, like why it is important, sir? It is important to ascertain on what event the ownership is transferred. Why? Because risk goes with the ownership. And for the purpose of ascertainment of a property or ownership, when the ownership is transferred, you should take into consideration all the terms of the contract and you have to ascertain the intention of the parties. That is what matters the most. What is intention of the parties, sir? When parties are having an intention to transfer the ownership. For example, I enter into a contract today, but payment will be done after 3 days. Delivery will be done after 5 days. When ownership is transferred? Today or after payment or after delivery? So because if we are not clearly agreed on what date ownership is to be transferred, then we have to apply the rules given in the act and find out on what event the ownership is transferred. Okay, so the main condition for transfer of ownership is that the first thing is you have to ascertain the goods, that is, it should be specific goods. Unless until the goods are identified and agreed upon, there can only be an agreement to transfer ownership, not a transfer of ownership. Okay, if I sell, let's say, if I make an agreement to manufacture and sell chairs, unless until I manufacture, I can't transfer the ownership. So ascertainment of the goods is one important thing, and intention of the parties. So irrespective of payment of money, irrespective of delivery of goods, the law provides the ownership is transferred whenever parties agree. If I entering into a contract today 13th and we have agreed that ownership is transferred 13th itself, but delivery will be done on 15th, payment will be done on 17th. When ownership is transferred? Today itself, because the intention of the party is clear and delivery of Goods and payment of money is not the important thing for the purpose of what? Transfer of ownership. Then what is the most important thing, sir? The most important thing is intention of the parties and ascertainment of goods. When it is not possible to ascertain the intention of the parties, when the intention of the party is not clear, then in that scenario we can ascertain, or we can decide when the ownership is transferred based on the following scenarios, following conditions. First one, if it is a sale of specific goods, means identified and agreed upon, and they are in what state? Deliverable state. Party's intention is clear, silent, means they are not agreed on what ownership is to be transferred. So if there is a sale of specific goods which is in deliverable state, in that scenario, the ownership will be transferred from seller to the buyer immediately. That is what law says. Irrespective of payment of money, irrespective of delivery of goods, the law says if there is a sale of specific goods, means identified, agreed upon, the ownership is transferred the moment the contract is concluded. You go to a showroom, identify a jewelry, make a payment, you keep it with the seller itself that you want to go to some other shop and I'll come back. Before you came back, the entire showroom got a fire or it is destroyed. Who would be responsible? Buyer, because ownership already transferred. Specific goods, deliverable state. Specific goods which is required to be put into deliverable state, means something needs to be done. If it is a specific goods and it is required to be put into deliverable state, in that scenario the ownership is not transferred unless until the goods is put into deliverable state, means in that particular state, and buyer has notice thereof. Buyer should be informed about it. For example, I have agreed to sell 1 barrel of oil, but you have requested, the buyer requested it to put into 2 barrels. Is it in deliverable state? Specific goods, correct. Is it in deliverable state? No, because it should be put into how many barrels? 2 barrels. So in this case, unless until it is put into deliverable state, that is put into 2 barrels, the ownership is not transferred. Next one, specific goods in a deliverable state, when the seller has to do anything thereto in order to ascertain the price. Specific goods, they are also deliverable state. Something needs to be done to fix the price. For example, weighing, measuring, or branding, grading. When such thing is to be done, ownership is transferred only when such thing is done, plus informed to whom? Informed to the buyer. Okay, when weighing is done plus informed to whom? Buyer. So these are the 3 rules in case of specific goods, and you have to apply these rules only when the intention of the parties are not clear from the contract with respect to transfer of ownership. So when the intention of the parties are not clear with respect to transfer of ownership from the contract, in that particular scenario we can decide based on these rules. Next one, unascertained goods, means the goods are in bulk form, are not identified and agreed upon. So in this case the ownership is transferred only when the goods are unconditionally appropriated, means separated from the bulk. There are 100 kg of 100 bags of sugar in the godown. Buyer agreed to purchase only 50. Now when the ownership is transferred, when either buyer or seller or both of them go to the godown, bifurcate 50 from the another 50, and the same is informed to the buyer, at that scenario what is transferred? Ownership is transferred. Next one, delivery to the carrier. Who is carrier? The one who carries the goods. Once the goods are delivered to a carrier without reserving the right of disposal, means without having a control over it, then The goods are deemed to have delivered to whom? Buyer, and buyer becomes owner immediately. But if the seller reserve the right of disposal, means if you still have a control over the delivery person, then the goods are deemed to be at the risk of whom? Seller. Seller is the owner. Next, goods on approval or a return basis. If the goods are sold on an approval basis or return basis, then unless until the buyer gives the approval, what is not transferred? Ownership is not transferred. There is an accounting for goods sold on approval basis. You sell the goods with the condition that the buyer either may accept it or he may reject it, or he can return it back. In this case, unless until buyer gives an acceptance, or if he keep the goods beyond the prescribed time, or he does something, that is he resell it, or he pledge it, or he destroys it, in that case what is transferred? Ownership is transferred from seller to buyer. Reservation of right of disposal. Right of disposal means having a control over the goods. If seller has a control over the goods and delivers them to the carrier, something happens to that, who will be responsible? Seller, because still goods are with seller. If seller doesn't have any control over it and he delivers the goods to the carrier, then who becomes the owner? Buyer becomes the owner. Okay, see, simple. If the goods are delivered to carrier, logistic company, without any conditions, means seller is not reserving the right of disposal. If he puts some conditions and then he delivers the goods, it means the seller has reserved the right of disposal. Then in that scenario, the ownership is transferred only when the goods are delivered to the buyer. Okay, section number 25, subsection 1. Where there is a contract for sale of specific goods, or where goods are subsequently appropriated to the contract, the seller may, by terms of the contract or appropriation, reserve the right of disposal of the goods until certain conditions are fulfilled. If seller reserves the right of disposal with certain conditions, unless until the buyer fulfill those conditions, ownership is not transferred. Where goods are shipped or delivered to railway administration for carriage by railway and by bill of lading or railway receipt, as the case may be, and the goods are deliverable to the order of seller or his agent, the seller is from facie deemed to have what? Reserve the right of disposal. Means you give the goods to the carrier, railway company or a logistic company, with a condition that they shall deliver as per the seller's instruction. Means the seller has a control over it. Unless until seller says, ownership is not transferred. 25.3. Where the goods are drawn on buyer for the price and transmit to the buyer the bill of exchange together. Means it is a conditional delivery. So unless until the buyer accept the bill of exchange, ownership is not transferred to him, even if the goods are delivered to him. So if the goods are delivered to a carrier along with bill of exchange, the ownership is transferred only when the buyer accepts the bill of exchange and gives the consent to the seller. Okay. Example, Magic Company Limited, based in England, shipped 50 tons of wool to Mr. Norton, based in Spain. Mr. Norton was supposed to claim the shipment through the bill of lading he received from Magic Co. Limited. However, when the shipment arrived, Mr. Norton was not present in the person at the dock. The wharfinger therefore took the shipment to his cloak room from safekeeping. Thereupon, producing the bill of lading, the wharfinger will then deliver the same goods to whom? To the buyer, because he is acting as his agent. Effect of destruction of goods we have discussed. If the goods are destroyed before the agreement, who will be responsible? Seller. After agreement, before sale, seller. But if the goods are destroyed after sale, that is after ownership is transferred, who will be responsible? Who will be responsible if the goods are destroyed after sale, that is after ownership is transferred? Is it seller or buyer? buyer will be held responsible. Awesome. Okay. Yes. Risk passes with property. What is property here? Ownership. Generally, section number 26 provides that in general, risk goes with ownership. Whoever is the owner should bear the risk of loss. Whoever is the owner should bear what? The risk of loss. But there are exceptional cases where the risk and the ownership may go at a different time. In general, risk goes with the ownership. Both go hand in hand at the same time. But there are a few exceptional cases where the risk may be transferred other than at the time of ownership. What are the exceptions? The first exception is that where the parties have that intention to transfer the risk other than with ownership. Let's say the sale happens on 15th, but parties have agreed that risk will be transferred only when the goods are delivered. Ownership already transferred, buyer becomes the owner. But parties have agreed, because parties have agreed that the risk will be transferred only after the goods are delivered. The risk will be transferred only when the goods are delivered. Exception. Second exception, in case of delayed delivery of goods. If the delivery of the goods has been delayed due to the fault of seller or the buyer, whoever under the fault, if it is seller under the fault, seller is responsible. If buyer under fault, buyer will be held responsible. Okay, so these are the two exceptional cases in which the risk will be transferred other than with the ownership. Done? Yes. So we are left with a transfer of ownership by non